Hello, class, and welcome to Chapter 3, Inside Criminal Law. Get the slideshow started. So criminal law, of course, is a huge part of the criminal justice system. So we have to talk a little bit about what are four sources of American criminal law. And we know that in any society that is like the United States, it's governed by rule of law. And so that's all persons and institutions, including the government itself, that must abide by this law. And as the rule of law has evolved over the course of history, Americans and their government have come to rely on several written sources of criminal law, also known as substantive criminal law. And these sources are the U.S. Constitution and the constitutions of various states. Of course, statutory law, which are statutes or laws that are passed by Congress and by state legislatures, plus local ordinances. And regulations, which are created by, regulations that are created by regulatory agencies. Okay, so that's going to be like your Food and Drug Administration or other federal agencies. And then, of course, case law, which are rules that are of law that are announced in court decisions. So when we're talking about constitutional law, let's go back up to that and talk a little bit more about constitutional law. So let me see if this goes into, it doesn't, okay. So constitutional law is based on the U.S. Constitution and the constitutions of those states. And the Constitution is the supreme law of the land. It is the basis of all law in the United States. Any law that violates the Constitution, as ultimately determined by the United States Supreme Court, will be declared unconstitutional and will not be enforced. So the 10th Amendment is dealing more with the limitations of the federal government and reserves the right to give the states the powers that are not granted necessarily by the federal government. Now, statutory law is statutes that are enacted by legislative bodies at any really level of government, but they do make up a source of law, and it's generally referred to as statutory law. So we have federal statutes, and those are laws that are enacted by the U.S. Congress. And then we also have state statutes, and those are laws that are enacted by state legislatures, or statutory law also includes ordinances that are passed by cities and counties. So with this legal supremacy clause, that establishes that federal law is the supreme law of the land. So there are essentially 52 different criminal codes in this country, one for each state, and the District of Columbia and the federal government. So today, according to a recent study, federal law includes nearly 5,000 offenses that carry criminal penalties. Inevitably, these federal criminal statutes are bound to overlap or even contradict state statutes. So in some cases, thanks to the supremacy clause of the Constitution, federal law will almost always prevail. The supremacy clause is a clause in the U.S. Constitution which establishes that federal law is the supreme law of the land, and it shall prevail when in conflict with state constitutions or statutes. So when we talk about on a state and local level, we're talking about ballot initiatives. So these are ballots where voters can write or rewrite criminal statutes through ballot initiatives. And in this process, a group of citizens draft a proposed law, and then they gather signatures to get the proposal on that ballot. And if a majority of the voters approve the measure, it's enacted into law. So currently, 24 states and the District of Columbia accept ballot initiatives, and these special elections have played a crucial role in shaping criminal law in each of those jurisdictions. So administrative law consists of the rules and orders and decisions of regulatory agencies. So A regulatory agency is a federal, state, or local government that is established to perform specific functions. So some examples of administrative agencies, might be OSHA, which is Occupational Safety and Health Administration, or the EPA, Environmental Protection Agency, or the FDA, Food and Drug Administration. So when you're breaking some sort of administrative rule, that can also be a criminal violation. Case law is cool. It's interesting to me because when we look at case law, this is what lawyers are using a lot of, is they're looking back at American law and they're looking at different court decisions or precedents that have been set through case law. And these rules of law include interpretations of constitutional provisions of statutes enacted by legislatures or of regulations that are created by some sort of administrative agency. So today, this body of law is referred to variously as the common law, judge-made law, or just case law. So when we talk about case law, we talked about the precedents that are set, but also this term, which is called stare decisis, which means to stand on decided cases. And under this doctrine, judges are obligated to follow precedents established within their jurisdiction. So why do we need laws? Why does society need laws? Well, many criminologists believe that criminal law has two basic functions. It relates to the legal aspects of society, and the other pertains to the society's need to maintain and promote social values. So we are going to be teaching societal boundaries by punishing citizens who disobey the law, right? That's the process. And so the term refers to a variety of harms that can be generalized to fit into two categories: harm to individual citizens, physical safety and property, such as the harm caused by murder, theft, or arson, and harms to society's interests collectively, such as the harm caused by unsafe foods, consumer products, polluted environment, poorly constructed buildings. So what is the social function of law? We have to maintain it, right? So many observers that believe, I'm going to leave it on this chart for now as we go through this. So many observers believe that the main purpose of criminal law is to reflect the values and norms of society, or at least those segments of law that hold power. Segments of society that hold power. So some scholars also believe that criminal laws not only express the expectations of society, but they teach them as well. So making burglary a crime, arresting burglars, putting them in jail, each step in that process reinforces the idea that burglary is unacceptable and is deserving of punishment. So when we're talking about criminal and civil law, we're going to look at this chart right here, and this will help you to kind of decipher the differences. So all laws can be divided into two categories: civil law and criminal law. Now, criminal law, which includes all types of laws civil law, which includes all types of laws other than criminal law, is concerned with disputes between private individuals and between entities. So one of the things that in law enforcement that we would often do is we would clear a call that's a civil matter, because people call the police for civil matters and don't understand the differences between civil and criminal law. Well, you're going to learn that, or you're learning that. So proceedings in civil lawsuits are normally initiated by an individual or a corporation, in contrast to criminal proceedings, which are initiated by public prosecutors. So such disputes may involve, for example, the terms of a contract, the ownership of property, or an automobile accident. But under civil law, the government provides a forum for the resolution of torts or private wrongs, in which the injured party, called the plaintiff, tries to prove that a wrong has been committed by the accused party or the defendant. So we have to talk about burden of proof. In criminal court, a criminal court is convened to determine whether the defendant is guilty. That is, whether the defendant has in fact committed the offense. But in contrast, in civil court, it's considered with responsibility, a much more flexible concept. Most civil cases, involve a request for some sort of monetary damages to compensate for the wrong that has been committed. So our burden of proof is greater in criminal trials. And although they're completely separate in our modern legal system, the two systems have some similarities. Both are attempting to control behavior by imposing sanctions on those who violate society's norms. And in the criminal court, beyond a reasonable doubt is the degree of proof that's required to find the defendant in a criminal trial guilty, beyond a reasonable doubt. And in civil court, preponderance of the evidence, which is the degree of proof required in a civil case, it basically means it is met when a plaintiff proves that the fact is more than likely is true. Okay, so we're going to stop for now, give you guys a break, and we'll come back and talk about the different categories of crime.